All right, if we could call the meeting in order. David Feynman called me about a half hour ago that he was stuck in a hearing in Naples and gave me a list of things to go over. So if you'll bear with me, I'm unprepared. Couple of announcements to start, and then we'll open up the floor to anyone that has any comments or announcements, and then we'll let Judge Delano have her turn.
I don't have anything today.
Oh, so it's going to be a quick meeting.
No, it is.
First announcement is that Magistrate Judge Mirando's investiture will be Friday, May 16th at 3 o'clock p.m. It's at courtroom 6, I believe. The bar will be putting together presenting some sort of gift to her on her investiture. We haven't determined what that is. If anyone has any ideas or wants to be a part of the presentation of the gift at the investiture, let David Feynman know. I was hoping to see Richard Johnston. I got the impression he headed up the investiture gift for...
Actually, at Judge Chappell's investiture.
For Judge Chappell's.
Richard was sort of the master of ceremonies for the long line of gift presentation, and Paula Mills is working to coordinate Judge Miranda's investiture. So I will mention that to Paula, because Richard did, for those of you who were there, did a fabulous job. It's a very long, dragged out process as everyone comes up to present their gifts. But he did a great job of just keeping everybody in line and doing the presentations really quickly. So I will mention that to Paula.
Thank you, Judge.
And that has nothing to do with who presents a gift, if there is to be a gift presented by the Bar Association.
And I think that David made a comment that he had been in contact with Ms. Mills. I assumed it was Lisa Mills, but it may be Paula Mills.
Paula has now got changed
Paula
her
is
name.
also a district court employee.
Well, I forget that.
Uh-huh.
So May 16th at 3 o'clock, I know many of us were at Judge Chappell's investiture, and I think it'd be good to have a good turnout at Judge Mirando's as well. The next meeting during the judge's setting in May, I think it's about May 15th or so, we're going to have Paul Giordano is going to have a panel presentation on receiverships. And there'll be CLE credit offered for that. And then likewise on the June meeting, we'll have John Webb will be presenting on dischargeability issues vis-a-vis taxes. So certainly for those of you that represent debtors, that should be very informative. Personally, I wanted to give an update on the Bank of America v. Sinkfield appeal. I suspect that most of you are now aware that the Supreme Court did not accept certiorari in that case. I think after our last meeting, Judge Delano had given me a synopsis of the NACBA amicus brief in the case, which basically argued that the court should not accept cert because the case had been brought before it in sort of an artificial way. For those of you not familiar, Bank of America v. Sinkfield is sort of the collateral attack on McNeil and lien stripping in Chapter 7 cases. I think at the bankruptcy court, Bank of America and the debtor had stipulated that the lien could be stripped and that McNeil was applicable. Then they stipulated to a direct appeal to the 11th Circuit, and at the 11th Circuit, they stipulated to an order affirming. I had read some blog posts that suggested that the plan was to get the 11th Circuit to consider the issue en banc, but they did move for rehearing en banc, and it was denied. And so Bank of America filed a petition for cert before the Supreme Court. And the NACBA brief argued that because of that artificial process, that cert should not be granted. And I read Larry Foyle sent around, I don't know who he sent it to, but sent around sort of like a blog post that seemed to insinuate that may have been the motivation for denying cert.
And the other possibility that the bankruptcy judges have been discussing is that the McNeil issue is unsettled in the 11th Circuit, and the 11th Circuit has McNeil before it and could resolve the issue. And depending on how the 11th Circuit rules in Bonk, there may be a conflict between the Circuit Courts of Appeal, and there may not be a conflict between the Circuit Courts of Appeal. So the consensus of the Middle District bankruptcy judges was that the Supreme Court felt that the 11th Circuit could take care of this issue before they got involved.
And I think that makes sense. And I would, the 11th Circuit would be the only, or is the only circuit that has ruled that you can lien strip in Chapter 7. I think you have decisions out of the 4th, the 6th, and I thought I'd seen a 9th BAP opinion that say that you cannot. And in the other circuits, there haven't been any appellate decisions. So I assume that for now, the judges will continue to grant those motions. And I haven't seen too many appeals of those decisions.
I think I've got maybe 3. They're all yours.
And they're all mine. And they're all stayed at the district court level as well. Judge Steele has been happy to let the 11th Circuit resolve the issue. And then that's all on my list. Does anybody have anything for the group? Where's Greg? Greg, no case law update this week?
I don't have anything yet. One of my cases to talk about that I lost. Sorry. No, I don't have anything.
I actually have something.
Okay. Thank you, Bob.
I've been sitting for the last couple of years on the district-wide steering committee, the purpose of which is to try to create uniformity amongst all 4 of the divisions. Currently, coming up to next meeting, we'll be talking about adversary proceedings. I've been sitting on a subcommittee of the district-wide steering committee where we're trying to determine where we can standardize the processes that have been used by the judges, and they do vary somewhat. So if anybody has any ideas that they want to email me about in terms of adversary proceedings, generally we're trying to put together a process that hopefully all the judges will agree to. Service of summonses, pre-trials automatically set or not. Initial discussions are, I don't even think the judge knows, perhaps putting adversaries in 2 different tracks, kind of like the district court does on its stuff, where the less complicated adversaries would get set on a pretty quick track with less discovery type disclosures, and then more complicated adversaries would be put more on a case management discovery type plan. And then we're also going to standardize hopefully the pretrial orders, and then also the trial orders, since some of them have varied somewhat between the divisions. So if anybody has any ideas that want to have them aired out at the next meeting, just email me and I'll make sure they're discussed.
Hopefully you all saw the note from David Feynman concerning the tangible personal property tax issue. What happened is we had a case that we sold assets like in 2008 or something really long time ago. Cases closed, assets distributed, and now the tangible tax department of the Lee County Tax Collector is going after the buyer of the assets, saying, we want the tangible taxes back from the time of the sale going forward, even though it was in a bankruptcy. And the problem is, as you saw with your note, is a lot of you have not had your clients on a corporate business kind of case, or even an individual DBA case, file any kind of notice of disposition. So again, the memo went out, but I would remind you to please, if your clients are involved in a business that's closed, for the sake of your clients, having them come back on you, and for the sake of everybody around, please remember, if you're involved in some businesses, to have that notice of disposition filed. Yes?
It's on the web. I put the form on the website.
Oh, okay, that's
Anybody
great.
wants the
That's
form.
good. That's outstanding. So no excuses. And anyhow, Brian has done a great job with the website and maintaining that. But just a reminder, because it can come back later.
Diane, and this is for Louise and Bob too. Have you folks had any movement at all on that dock stamp issue with the estate liquidating real estate interest?
Where we're at right now, what I've told my buyers,
Yeah.
that I have one large buyer who's agreed to pay the tax but is kind of holding off. I said, session closes, I think the 5th of May, and they're trying to work with the governor and the Department of Revenue to, I don't know if they're trying to get excused or get some sort of revenue ruling adjustment, or no clue what they're trying to do, but I know there are lobbyists working on it. I told them, if nothing happens by May 5th, I want a check, and he's got a list with a breakdown on all these cases by the 7th of May, because I have to file by the 12th of May a report itemizing all the sales that I've made in the last 3 years, and what potential dock stamps, what was paid on each of the cases, whether that was enough or not enough, or so forth. And I'm proposing, and I filed some motions in some of my court cases already to get authority to pay those the dock stamps out of the cases to the extent that I have money. And so far, I don't think anybody's opposing it. And in the U.S. trustees taken the position, at least to me, that as long as we don't seek to pay more than the amount of the sale, they don't see any prejudice to creditors, because it was a negative equity situation in the first place, so they didn't see any reason to oppose it. I only have one or two, really, the ones I've sold, where I'm even going up to the amount of the sale. For the most part, knock wood, they're below it. And I have one or two where I know the firm's going to have to come out of pocket, but because you can't find the people. But given what the exposure could have been, I'm not going to cry too hard.
Gotcha.
So, but that's where I'm planning to file the report on the 12th of May. I don't know that the other trustees have the same intention or what they're planning to do, but that's my one person. I think you're not planning to file it at all, right?
I'm doing a partial disclosure.
Okay.
Not that I'm saying I'm not going to pay the dock stamps, but on ones where I know that I'm not going to find the buyer to do what they agreed to do, and then also ones in which I have some money in the estates. Because I think that these investors, the buyers, for the most part, were relying upon DOR directive that they were to pay dock stamps on a lower amount. So, I mean, that's as much as I've been told. There might be some room for them to negotiate a better deal. And so, to the extent that they've agreed to protect me and by depositing money to cover it if they had to, that's kind of what's been going on. So, I'm not going to undercut their efforts.
Yeah.
But, at the same time, it's all going to get resolved at some point.
Yeah, I gave them a deadline, and they understand and seem to accept that, since once the other thing I'm doing is, if anybody sees a notice of sale on a go-forward basis, you'll note that my language is substantially changed on the notice of intention to sell, and we are requiring the buyers, A, to put a deposit down before we even process a notice of sale, and B, they have to agree to pay the dock stamps up front, and we're effectively taking two checks. We're getting one check for the amount they owe the estate, and we're getting a second check, and we're sending out the email letter that says this is how much we're going to collect for all the recording costs, which include dock stamps. So they know going forward that they have to pay those, and we're going to make sure they pay those, at least in our firm's office, that by them having to pay it up front, or they're not going to get a deed, and we're not going to record it. So, and actually, I'm still getting buyers. So
Yeah, they're still.
I mean, they're still willing to do it. I was just They just, you know, they may slightly bid lower on some of the cases, but, you know, instead of what might have been a $3,000 or $4,000 check, it might be, you know, 2,500 or, you know, 2,000 or something. And of course, I'm not going to just sell, if that's the only asset, for $2,000, I'm not going to do it. But if there are clearly other assets in the estate, then we will. So, any other questions on that issue? So, that's our position right now.
Judge, no comments today?
No comments.
Okay. Well, I think that we're adjourned then. Next meeting will be in May, and again, we'll have, you can get with Paul Giordano for the details, but I understand it's a panel discussion on receiverships. CLE credit will be available, and then in June will be John Webb on dischargeability of taxes. All right? So everybody have a nice month. Thank you.
Thank you.
Thanks, Doctor.
Yeah.